Hello everyone, I'm Professor Meredith Muller. It's nice to see you again. I hope that those of you studying for the upcoming bar are giving it your all and that you're doing well. And I hope that you are doing as many practice essays as you possibly can. Which brings us to today. Today we're going to go over the second free practice essay, which was on negligence. So let's jump right into it. The question that I gave you, of course, is a negligence question, and it states, it is against the law to text while driving. Defendant was texting when she veered out of her lane and hit plaintiff's car, causing plaintiff's injuries. Discuss the possible claim that plaintiff has against the defendant. Okay, so hopefully you've been studying and you immediately recognize that this is a torts question. Not only do you recognize that it's a torts question, but you recognize that it is a negligence question. That is your key issue. Anytime you have a plaintiff being injured and it's a civil claim and it's not an intentional injury, so you don't need to talk about intentional tort, you need to consider negligence as a possible theory. Okay, so let's talk about how we are going to tackle writing a negligence essay. So the first thing that I would do is I would begin my essay by stating what the major issue is. The major issue is what claims does plaintiff have against defendant? You might be able to state, does plaintiff have a negligence claim against defendant? And then in following IRAC, the next thing you do is that you state the rule. Well, what is the rule for negligence? We know that negligence is proven when defendant owes a duty to plaintiff and breaches that duty and causes damages. Okay, so duty, breach, causation, and damages are the elements that we need to prove negligence. Okay, so now what we do in our analysis is we need to break down or unpack each one of those elements to show that defendant was in fact negligent. If you don't have all of these elements, then there is no negligence. So we have to start with duty and see if there was a duty that was owed by the defendant to the plaintiff. Now, when we talk about duty, there are both the Andrews and the Cardozo's view. But in general, on an essay, we're going to be able to simply say that you owe a duty of reasonable care to all foreseeable plaintiffs. So that is your standard. Your standard of care is reasonable care owed to all foreseeable plaintiffs. You don't really need to get into the Cardozo and Andrews view unless you have an unforeseeable plaintiff. Here in this fact pattern, we happen to have a foreseeable plaintiff. And our foreseeable plaintiff is a driver on the road. So if you're a driver on the road, other foreseeable plaintiffs might be other drivers on the road, it might be pedestrians, it might be skateboarders, might be bicyclists, motorcyclists, etc. Anybody that could foreseeably be injured, okay, in your zone is a foreseeable plaintiff. Okay, so we owe a duty of reasonable care to all foreseeable plaintiffs. Note also that in this fact pattern, we have a law. We say that it's against the law to text while driving. Anytime that you see a statute or a law or an ordinance or a rule, something like that mentioned in a negligence action, that is a red flag fact that should trigger you to talk about negligence per se. Negligence per se, if you remember, is a way to establish both duty and breach. So if you have a statute or a law, it establishes that duty for you. Here, our duty is to not text while driving. It's against the law to do that. So we have a duty to both act reasonably to all foreseeable plaintiffs, and we also have a statute that defines our duty to not text while driving. Then we're going to move on to breach. Second element of negligence is breach. Okay, so let's go ahead and follow the regular negligence analysis without getting into negligence per se just yet. Did we fail to act reasonably? Did we fail to act reasonably? Okay, so if this were a question that was packed full of issues, you might be able to just quickly say, it's not reasonable to text while driving. It's dangerous. period, and move on. Therefore, defendant has breached his duty. But if this is the only issue in your question, and you've got an hour to answer it, so this is a think-em question. Okay, and think-em questions, you need to really get into depth with your analysis. The grader wants to see how you think and how you can analyze a particular element or claim. Here, in this essay, we really only have one main issue, which is negligence. So this is a think-em question. So when we talk about breach, we probably need to get into a little bit more depth. So in think-em questions, when you need to talk about what's reasonable or what's not, or if it's questionable as to whether or not the actor's conduct was reasonable, you need to discuss the learned hand test. Do you remember the learned hand test? That's that fun one where we take calculus and we talk about the probability and gravity of harm, and we weigh it against the burden to protect against it. With the learned hand test, we have to find that the probability times the gravity of harm is greater than the burden to protect against it. If we find that, we're going to find breach. Okay, so learned hand test is a way to figure out whether defendant has breached his duty of care. So here, if we take that formula and we plug it in, we say, okay, the probability of harm, if you're texting while driving, is pretty high. You might get in an accident. Okay, you're more likely to run a red light. You're more likely to hit somebody. You're more likely to crash your car. Okay, probability pretty darn high if you're texting while driving. Gravity of harm, it could result in death. Car accidents can result in death. That's pretty high. Okay, at least bodily injury, property injury, probability is pretty high. Gravity is pretty high. What's the burden to protect against it? Don't text. Answer your text later. That's a very small burden. So here, since we have a high probability of harm, a high gravity of harm as weighed against a low burden, we have that failure to act reasonably. Also, you'll notice in some questions that utility also becomes a factor in the learned hand test. For example, if you're speeding, normally that burden and gravity would be high as weighed against the burden to protect against it, unless you're rushing a dying child to the hospital. Okay, in that case, utility comes into play, and that's something that allow a fact finder to not find breach. Okay, so keep utility in mind. In this particular instance, it doesn't really matter. We're not told why we're texting, but we're assuming it's not for the best reasons. Okay, so now that we have breach shown through learned hand test, we need to also show that we can establish breach through negligence per se. Okay, so again, we mentioned that we had a statute, and the law is to not text while driving. Okay, we cannot text while driving. It's against the law to do that. So whenever you analyze negligence per se, you're going to say that the duty is established by the statute, say what that duty is, and then establish the elements of negligence per se. Now, the elements of negligence per se are, number one, the plaintiff is in the class of persons that the statute was designed to protect. Number two, the type of harm that occurred was the type that the statute was designed to protect against. And number three, finally, defendant's conduct was not excused. So let's take those and plug them in, just like we did for the learned hand test. Let's plug in our facts. Number one, plaintiff is in the class that the statute is designed to protect. Okay, plaintiff is a driver on the road. Okay, again, our defendant was texting when she veered out of her lane and hit plaintiff's car, causing plaintiff injuries. Okay, so we don't want people texting and driving because we don't want them to get into car accidents with other cars on the road because of somebody texting and driving. So therefore, she's in that class of plaintiffs that the statute was designed to protect. Number two, it's the type of harm that the statute was designed to protect against. Well, what is our type of harm? Okay, she got injuries from a car accident. Okay, one of the reasons we have the rule that we shouldn't text while driving is so that people don't get injured in car accidents. That's exactly what happened to her. So this is the type of harm that we were designed to protect against. And then finally, defendant's conduct is not excused. We don't have any facts in here that tell us, again, why defendant was texting, if it was an emergency, if there was somebody's holding a gun to his head and saying text. We don't know what's going on here, but it doesn't seem to be an issue. So we can assume that the defendant's conduct is not excused. Therefore, negligence per se is established. Therefore, breach is established. So we have now established breach through both the learned hand test and negligence per se. A lot of students now quit. If you quit now, you will fail. Okay, you can't fail here because negligence requires 4 elements: duty, breach, causation, and damages. We haven't done causation and damages yet. All you've proven is duty and breach. Just because you establish negligence per se does not mean that you have automatically established negligence. You have to finish the remaining 2 elements. So let's talk about causation. Causation with negligence, I would divide it into 2 parts. Both cause and fact, okay, or actual cause, and legal cause or proximate cause. I don't care what you call it, they're the same things. Okay, actual cause is the same thing as cause and fact. Proximate cause is the same thing as legal cause. And again, I would discuss them separately. So let's start with actual cause. Actual cause means that but for defendant's conduct, plaintiff would not have been injured. Okay, you've got to establish that link, okay, between the conduct and the injury. Okay, well, this is pretty clear. But for defendants texting and driving, plaintiff would not have been injured. There wouldn't have been a car crash. Defendant wouldn't have veered out of his lane, hit plaintiff's car, caused the crash, plaintiff injured as a result. Okay, so actual cause is therefore established. All right, now let's do proximate cause. With proximate cause, that some students get it so messed up in their minds, and it's really not that confusing. It's all about foreseeability. Okay, was what happened foreseeable? And you can talk about foreseeable type of injury, foreseeable plaintiff. Again, if you had an unforeseeable plaintiff, this is another place where you would discuss it. You can talk about those bizarre instances where somebody gets hurt by something just crazy happening. Okay, that might be a proximate cause issue. Otherwise, you just ask yourself, was what happened foreseeable? Is it foreseeable that plaintiff would have been injured in a car crash because defendant that was also traveling on the road with her was texting and driving? Yes. It is completely foreseeable that defendant could text, get in a crash, and hurt somebody. And that's exactly what happened here. So we have established causation, both actual and proximate cause. And finally, damages, really easy. We have to show that plaintiff suffered damages as a result. So all you do is you say that the facts tell us that this car accident caused plaintiff injuries. That's what the facts tell us. We might be given more. We might say she has a broken arm. We might say that her car was totaled, that she lost her purse. There's all kinds of things that could go on here. But the main thing is that we're told that it caused plaintiff injuries. Therefore, our damages are established. And then you can conclude, wrap up your big giant issue with a nice neat little bow. Remember, the original issue question was defendant negligent? Okay, or does plaintiff have a claim for negligence against defendant? And the answer is yes, because defendant owed a duty to plaintiff and breached that duty, causing her damages. And then you're done, and you pass. So the tips I can give you here, the takeaways that I want you to get are, first, if it's a question that only tests, a few issues, know that it's a think-em question as opposed to a racehorse question. And they want depth of analysis. Okay, the graders are looking for how well you're going to analyze each issue. So you're going to use the facts. Even though this was a very short fact pattern, we really used the facts here. So pay attention to how we did that. Okay. Also, whenever you're discussing negligence, make sure you discuss all 4 elements. Don't stop at breach. A lot of students do, and a lot of students fail because of that. Make sure you include causation and damages. Also, anytime you see a statute, a law, an ordinance, any rule, okay, that applies to your case. Make sure you discuss negligence per se as a way to establish duty and breach. Just don't get so excited about negligence per se that you forget about regular old reasonable conduct. Okay, and apply the learned hand test if it fits and if it's a think-em question. Okay, then finally, make sure that you take each element and address it separately. Give it its own IRAC paragraph. Okay, for example, our big issue here was defendant negligent. Okay, our 4 smaller issues was what was the duty? Was the duty breach? Okay, were the damages caused by the breach? And then finally, were there damages? Okay, so make sure that you discuss each separately and completely. It also helps to use headers, topic headers, underlining. You know, your graders are looking for those legal terms of art. They're looking for duty, breach, causation, and damages. They're looking for actual and proximate cause. They're looking for the words negligence per se. So you need to underline those things, highlight them for them, because sometimes these graders grade really fast. All right, well, I hope this helps. Good luck practicing. Keep practicing your negligence essays, especially if you didn't recognize negligence per se on this one. And drop me a line if you need any help. Bye-bye.